Hello friends, in my YouTube channel Advocate Amit Kumar Gupta, the case which I am going to discuss today is PRITI NANDA versus Commissioner of Income Tax Appeals. This case has been decided by Delhi High Court in the writ petition filed by PRITI NANDA, and the judgment came on July 11, 2022. In this particular case, the assessee was before the my lords for a very limited issue. In this case, the assessee was facing assessment proceedings, and due to which the demand was pending, and the assessee has gone into the CIT appeal. And when the appeal was filed, 2.5 years have passed, that no action has been taken by the CIT appeal for disposing the appeal of the assessee. But in the meantime, the bank account of the assessee were attached and 20 lakh rupees were collected as tax from that bank account. So the assessee filed the writ petition before the Honorable Delhi High Court. The assessee said that it is not my fault, I have filed the appeal in time. The department was saying that first of all the appeal was manual, now the appeal has been transferred to the National Faceless Appeal Center. The assessee was before the Delhi High Court for releasing of the money. But in this particular case, the court directed the assessee that the assessee should make a request to the National Faceless Appeal Center for the early disposal. The relief which the assessee got in this particular writ petition was that the court gave the direction to the respondent who was CIT appeal in this particular case to dispose of the appeal within 4 weeks from the date of filing of the application of the early disposal of the appeal. But the matter for which the assessee was before the court was that the money which the department has taken forcibly from the bank account by using the powers of section 226. So the question arises that in this particular case the assessee went to the to the writ court. But in every case, all the assessees are not going to the writ court because it is a costly affair. So it means that for getting the direction for the early disposal of the appeal, it means that if the assessee has to go to the writ, then what will be the fate of the lakhs of appeals which are pending before the CIT appeals? There is no disposal since last near about 2.5 years to 3 years, due to which the appeals are piling up. So when this CIT appeal will start reacting, it means that they will dispose of the case in a very hurried manner, like the assessments are done. So it is very questionable that the quality of the CIT appeal orders is going to be very painful for the assessee. In the past also we have seen that not much relief is given by the CIT appeals. They are not giving the relief to the assessee on the technical questions. Technical questions are left to the ITAT or the high courts. So it means that they are not fairly disposing of their duties. And they are the part in the machinery of the judicial system where the matter is stuck for a such long period of time, due to which the interest of the assessee is increasing, which the assessee has to pay. And in the meantime, the assessee has to face the coercive action of the tax recovery officer or the income tax officers. There is no system where the applications of the assessees for the stay of demand is disposed of by the assessing officer or the CIT appeals. So there should be some common order from the CBDT that if any application is made by the assessee for the stay of demand, then that application should be disposed of on a priority basis, and that too judicially and by a very speaking order. The quality of the assessment orders is very weak nowadays. The way the notices under section 148 A clause B are issued and then they are transformed into section 148 notices is very pathetic. and every time the assessee is going to the writ courts, the assessee only gets some relief in the manner that the matter is reverted back. So this is my humble request to the government that in this forthcoming budget there should be some provision in the law that if any matter will go to the writ court and the court feels that the standard procedures are not followed, then that notice will not prevail in the eyes of the law, and that there in no case the department should be given the second innings to play. So in the concluding remark, in this case the assessee got the relief from the writ court that the directions was given to the CIT appeal to dispose of the matter in 4 weeks when the assessee files the application for the early disposal. At the end of this video, once again I am repeating the name of the case. The name of the case is PRITI Nanda versus Commissioner of Income Tax Appeals. Thank you, friends.